We're going to get started in a few minutes. Please take your seats. We have Seamus Linsky here from the Oregon Trawlers Association, who's going to make a couple announcements. Seamus.
Thank you, Blaine. Good morning, everybody. I'm Seamus Linsky. I'm the Membership and Political Director of the Oregon Trawlers Association, but that's not why I'm here today. I'm here today to give you some free stuff. I've got the announcement of all the exhibitor drawings for you. So first off, Tony Robinson and Nolan Robinson of Ringler Associates had a Kindle that they raffled off, and Steve Hill is the winner of that. Is Steve here? Nope. All right, I'll let him know. We've got BECU Trust Company. They are giving out a $75 restaurant gift certificate, and Mike Maxwell is the winner of that. Is Mike here? All right. So the winners, you will just go to the exhibitor booth and pick up your gift at the exhibitor's booth, okay? We've got a Starbucks gift basket from Vernon Court Reporters. That's Sonia Fisher. Sonia here? Oh, right there. All right, great. And we've got 2 gift baskets from Case Forensics. We've got Daniel Snyder. Is he in the room? Dan, there you are. And Joe Cunane. Is that how you pronounce that? Is Joe here? Nope. Okay. We've got an American Express gift card from iBridge, and that's Lara Johnson. Is she here this morning? Where is she? She's not in the room. All right. I'll let her know. 2 sets of books from Financial Forensics, and the winners are our next speaker, Tom Booth.
You won something. You won
And
books.
Duncan Turner. Is Duncan here I know, I saw him this morning. He's here, but I'll let him know. All right, and we've got a basketball autograph by the Portland Trail Blazers from Nagley, and Dan Snyder wins that too. All right. Bottle of port wine from Schwartz Legal Nurse Consulting. Frank Ladenburg. Is Frank here? All right, Summit Pharmacy. We've got 3 winners here. We've got an Apple TV, and that's Rob Kinney. Is Rob in the room? No. Gift card, Jonathan Stubbs from Washington. Is he here? Oh, Rob, you are here. Okay. And a gift card for Tara Lawrence. Is Tara here? All right. And let's see, Summit Pharmacy, Apple TV. Okay. Fat Pencil Studios, a $200 gift card for their services. Mary Lou Hazelwood. Is Mary Lou in the audience? Nope. And LNS Court Reporting has 2 $50 gift certificates to Powell's Books for OTLA members and 2 $50 Amazon gift cards for Washington members. So from Oregon, we have Jeff Merrick and Kim Tucker. Are you guys here? There's Jeff. Is Kim in the room? Kim was just outside. Okay. You don't have to be here to win. I just have to know who to find and tell. And then Tara Lawrence, I thought she was, and Angela Macy Cushman. All right. And MedRex has a $100 Nordstrom gift card for Angela Macy Cushman. She won that too. Is Angela in the room? I'll let her know. All right, and my last announcement is, well, first of all, I'd like to thank all of our exhibitors. They help put this convention on, so I'd like to give them a round of applause. And then the big grand prizes are, if you've filled out your exhibitor passport, if you've made it around and talked to all of our exhibitors, you get entered into a raffle for 3 prizes. The top prize is an Apple iPad, and then Washington's giving away a free convention tuition for next year's convention, and OTLA's giving away a free convention tuition for next year. We're going to do those drawings after the CLE today, and we'll announce them at tonight's Saturday night party. So if you haven't gone around and had them all checked off, you've got until the end of today, basically, because the exhibitors will have broken down tomorrow. So thanks, everybody, and with that, I'll turn it over to Paul.
Thank you. Well, the next speaker is Thomas Booth, who's going to talk to us about 5 quick depo tips to use in most depositions. His practice is primarily employment cases. He graduated from Stanford with a BA in psychology and Stanford Law School in 1978. He's admitted to practice in Oregon, Washington, and Texas. He's a member of the National Employment Lawyers Association, the Washington Lawyers Association, the Multi-Million-Dollar Advocates Forum, American Society of Trial Consultants, and American Psychology Law Society. Do you know, Thomas, when I started out more than 50 years ago, there was virtually no discovery. It was a lot like Oregon. There were no interrogatories. There was what was called a bill of particulars. You could ask a few questions, but not many. No depositions, rare depositions. And we had code pleading, which meant you had, like Oregon, you have code pleading. Well, we had code pleading, so you had to plead correctly and learn there were things like negative pregnancy and all kinds of things. And that meant at trial, the first time you knew who was going to testify is when they took the stand. And you didn't have a clue what they were going to say. And you waited around and you were very careful on cross because you didn't know what was going to happen to you. And cross was short because you wanted to get out before you were hurt. But today we have extensive discovery, and all of us need tips on depositions, Tom, so I'll give it to you.
This really more closely resembles a Deposition Tips 101, but there's some things that I think are worth remembering every time we prepare. Probably the first step when you're getting ready, I think, is to go back and revisit the complaint. It seems simplistic because you prepared the complaint, but it may have been months before. As important as that is as a pleading, always look at the answer. I don't know how many of you are seeing these, but in my employment cases, I'm seeing 9, 10, a dozen affirmative defenses, many of which have absolutely no basis. And by reviewing those, try to build out of the defense or the witnesses who are allied with the defense the basis for summary judgment motions to take out those offensive affirmative defenses. It's also worthwhile to visit the jury instructions. Now, I'm presuming that every one of you looks at the jury instructions before you draft your complaints. Even if you've done hundreds of the complaint, it really is worthwhile to take those 5 or 10 extra minutes to revisit the key jury instructions that you're going to encounter. The reason for this, at least in Oregon, is to make sure you've pled all the elements you need. In Washington, to put the other side on notice to avoid a motion for, at least in the employment field, not setting forth a sufficient basis to avoid summary judgment. It's also worthwhile to revisit what you think you'll face in summary judgment. But more than anything, I would urge you to stop thinking about discovery depositions. You hear that expression used all the time. Deposition is helpful for discovery. But really more than anything, what we want from discovery, particularly from a deposition, is to gather, to harvest those sound bites that we can use at trial. For those of you who are in a case, such as my employment cases, that are almost invariably going to receive a motion for summary judgment, look at the case law, take a look at the key lines, flip it into a question, and ask the defendant the very passages you want to cite in opposition to their summary judgment. And it is wonderful fun. And I don't take the case and say, are you aware of this case? Will you admit to this? But bury the question in your deposition. And I can't exaggerate the joy in meeting a summary judgment motion with 10 or 15 quotes from the defendant or those allied with defense interests that completely mirror the guiding case law. One hopes it makes it easier for the judges to deny their motion for summary judgment. It unfortunately doesn't always, but it helps. The other thing I think you should do is draft your closing argument. I like to outline my closing argument the minute I first meet my client, because that's usually the core of the story, unencumbered. It's the forest unencumbered by the trees. And it's usually the kernel of the story. Sure, it refines. But going through deposition preparation, I'm writing what I want to say in my closing argument. When I'm taking all the defense depositions, I'm looking to prove my entire case. My goal is for my client to have to do nothing but walk up to the stand, smile, and be worthy of attention from the jury. My goal is to tell my entire case by third-party witnesses who have no axe to grind in this battle, or defense witnesses from whom we're extracting statements that help assure a plaintiff's success. Second, how many of you are confronted after deposition breaks with a witness? Let me step back. You've scored some points, and the defense attorney looks at you. You're just 30 minutes from the last break. You're fairly confident that the witness has not wilted in those 30 minutes and is not in imminent threat of demise. But the attorney calls a quick timeout, wants a break for some imagined reason. What I really like to do is, after each break, every break, walk through essentially this line of questions. Did you talk to anyone? I don't want to know what they said. I just want to, did you talk to anybody? If they didn't, I'll go right to, did you make any mistakes in the answers since your last break? But if they did talk to their attorney, each of these questions starts with this. After talking with your attorney, are you now aware of any mistakes you made since the last break? After talking with your attorney, would you like to change any of your answers since the last break? After talking to your attorney, would you like to add to any of your answers after the last break? And after talking with your attorney, is there anything that the two of you think I should know, or we should know at this point? Now, what's fun about that is if you skip walking through these steps and you're trying to impeach somebody at trial, social science studies indicate that the jurors more closely ally with sympathy of the witness than they do with you as the attorney. And jurors realize they make mistakes. So if you've not done anything to intensify their testimony and you're trying to impeach them, you might count coup. But if you can stand up in the impeachment and say, remember the deposition? I won't walk you through the whole speech because you all could do it in your sleep. But to then turn to them and say, do you recall that 8 times during your deposition I offered you a chance to correct your testimony? Do you remember I asked you 8 times? After talking with your attorney, did you want to change your answer? And no. Well, who have you spoken to? That's actually a bad way to do it. What's happened that's changed your testimony since then when you had these 8, 9, 10 opportunities to correct it, and you chose not to? And I found that it really does fix it in the jury's mind and intensify the impeachment. We all know that our goal in deposition is to exhaust a topic, box in a witness, sort of fence them in, hopefully better than that fence would do. But one thing I'm running into increasingly, and maybe some of you have too, is the position that, what's that word mean? Every deposition, I take a little pocket dictionary with me, and it's actually kind of fun to walk the deponent through a very simple word definition, ask them if they've used the word before, which they have always used, and see if they disagree with the dictionary, and then go forward with that. And it tends to shut that approach down, or that defense, all the time. Video every deposition. And we've heard some talk about high tech. It's awfully expensive. So you can take your iPad, get a camera, videotape every deposition. If you're trying to save money, do it yourself, except on perpetuation depositions or key defense depositions where you're sure you're going to be harvesting those. Those, I think it's worth investing in a videographer. I want to take just a moment to set this up. Had a case where it was a quintessential he said, she said. A licensed teacher grabbed a certified employee twice. There's no evidence of it. We heard from all of the administrators from the top down that was just Paco being Paco. He's kind of a joyous guy. He's a happy-go-lucky guy. He touches people when he talks to them. And we were facing that, and I'll tell you, for a pit in your stomach, Monday morning before trial started, this judge, who's really a very good judge in the Portland area, said that she'd gotten back and read her materials and was surprised I'd taken the case, which is not really an optimism-inspiring comment to hear from your judge on the first day of trial. And that on reflection, she'd talked to her son last night, the prior night, who was stationed in Iraq, and it shared with him the same thought, and it occurred to her again on the drive in. Now, fortunately, that was just the attorneys in back. The defense attorneys are weak-kneed with joy, and I'm thinking, what they didn't know is we'd videotaped this guy's deposition. And that's what we saw at the deposition. You can read lips.
You've already.
What, during the term of dismissal?
Exactly. No, neither one.
So no time during Smith's employment at Rex Putnam High School.
You've already.
What, during the term of dismissal?
Exactly. No, neither one.
So no time during Smith's employment at Rex Putnam High School. So no time during Smith's employment at Rex Putnam High School. Yeah. It was a plaintiff's verdict. But what was so much fun is to set that up. Often you don't want to bring the defense up in the middle of your case because they can drive a truck through your case. So I brought Paco up just to ask him a few questions about the deposition. Drew the table where he'd had the deposition, got him to agree where everyone had sat, confirmed that he really wasn't angry at anybody at the table, confirmed that he wasn't offended by anything any of us had done, walking around the table. The defense is up objecting. I'm saying just a little latitude, Your Honor. And then got him to talk about how he had never spoken ill, never insulted women, had not said anything rude about my client. And he laughed and said, well, only around the house, ha, ha, ha. And the jury's laughing with him. I'm thinking, this is cool. Let him sit down. What are they going to do? They tried to do a broaden the exam, and I objected to scope. And I said, Your Honor, I'm totally willing for them to ask any questions about how we sat at the deposition. And so that was the end of that. Then I brought up a videographer who brought the screen up. Now, there were 4 enhancements, and to get those, we had to send it back to a lab in Virginia that does work for the NSA, FBI, and CIA. Is this true?
That's right. Keep going.
Can I just have one more?
Keep going.
And the videographer got up and presented it, and as the screen gets bigger and bigger and bigger, and I wanted to in a courtroom, it's more dramatic than it is there, boom, boom, boom. Defense is on their feet after the 3rd play and objects, and the judge steps forward and starts to rule, and just as she steps up, he utters his last comment, enhanced. She turns around surprised because she's now heard it from behind her, and I was able to sit down and say, thank you, Your Honor, nothing more. And the jury did find it significant in undermining their confidence in Paco's story that he had never taken a negative attitude towards women or done anything adverse to my client.
What was that comment?
I'm sorry, you bitch. He looked at my client in the deposition and muttered under his breath, you bitch. No one at the table heard it except my client, and we won't go into the social psychology of why she would hear it, but believe me, if anyone at the table had heard it, she'd be it. And the videographer who had his headphones on talked to me at break and said, I'll get the tape over to you as soon as I can, but I think you want to check something out. And we tried as hard as we could in our office to amp it up, and we couldn't hear it clearly. We could read his lips, but it didn't lack the power that it did as it got bigger, 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 and slower, 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 and that's where the enhancement came in. The last point is in deposition, what we've taken to do is training our clients in a different way of dealing with depositions from the defense that, I know it looks like sort of 2001-ish, is of camera lens. Most of you are probably having all of your depositions videotaped and your plaintiff's depositions videotaped. What we've taken to doing is teaching our clients to talk only to the camera. Ignore defendant. A couple benefits for that. If you have a highly aggressive defense attorney, that can rattle your witness. If you have a charming defense attorney, I personally like to sit back and lean in slowly, ever more slowly, talking to the witness who I'm examining, smiling, nodding, mirroring, doing everything I can to create a bond, and then run a test mirror to see if they respond. If they do, go right into the heart of some questions. Then when that bond is broken, rebuild the trust and go at it again. Having them stare at the camera lens, they have no connection with the attorney. And surprisingly, I've seen skilled defense attorneys unnerved by an opponent who never looks them in the eye through the entire testimony. And finally, when it's played at trial, there are no shifty eyes. They're simply talking to the camera. And we do that with hours of preparation with a camera, and we have them go home with a spouse or somebody else and teach them to stare at the wall while other people are talking to them. And we find with the discipline, it really does relax them in deposition, gives them a feeling of greater control, and creates a better bit of testimony when it's played back at trial because they're talking to the jury. Remembering the camera lens is the eye of the jury. I ran over, I'm sorry.
Don't go away. Don't go away.
Okay.
Thank you. That was good. Sounds to me like sounds to me like we could give a talk on neuro-linguistic programming and mirroring.
Well, yeah.
I mean, this is a great concept.
Are you an
but-
old NLP guy?
Yeah, absolutely, but this isn't the time. But that's the next time you and I should talk about that. Robert Dawson, where's my friend? Robert Dawson went through the Spence Trial College. He's been my friend for a very long time, and he's a control freak like I used to be before I was reformed. And I know you've got procedures for DEPs. I would like you to, this is a little challenging for you, but I'd like you to share with us some of the things,
Oh, great,
expert
yes.
depositions. What do you do? You have to stand up. You can't sit
Actually,
there.
let me come up to the mic.
No, he doesn't. Oh, God, never give him the mic.
All right.
Never. No. He had 5 things. If you go more than 5, you're done.
At least this way they get something of value out of the session.
do much in the way of discovery. I hope I have understood the case and the expert's opinions through my own expert before I even sit down. So I am looking for the items to cross from, the items to kill them with, admissions, concessions. That's what I'm interested in. I want to frame rules. I want to make it so that when that expert sits down, the jury goes, I am afraid of the world we live in with that expert, if that's the way it's going to work. That's basically my goal.
What do you say to that, Andy?
Sure.
Sure. Thank you, Robert. You had a question right here in front of
Oh,
us.
no, he's the next speaker.
You're
He's our
oh,
next
you're
speaker.
here.
He's
You're
our
the
next
one I
speaker.
wasn't going to let talk if you weren't here. Okay, Joe, good to see you.
I'm trying to help you, Steve.
Yeah, right. Steve, excuse me. Anybody else? Do you remember? No, that isn't that simple.
Okay.
You don't remember, God rest his soul, Dan McKelvey. But Dan McKelvey used to ask experts in malpractice cases to define malpractice for him, the defense expert.
Oh, absolutely.
And I was always intrigued, because I associated with him on cases. I was interested to see the various interpretations, which generally were intentional harm, was their idea. He was able to do a lot by getting people, I was thinking of your dictionary.
Oh, we do the same in the employment setting. I always ask, what's sexual harassment, what's discrimination? And I walk them through all the terms that are going to be drawn out of the jury instructions, because it's wonderful fun when the defendant defines the terms by which he is going to be judged.
And that's what you're doing with your interrogatories. Excuse me, your jury instructions.
Yes.
You're going to your jury instructions, incorporating language and asking
Yes.
it. That's good.
The whole idea then is, I'm sorry, I'm running
No, go
over.
ahead.
Is that way, I presume all of you in closing probably lift some of the jury instructions out, maybe simplify them, project them on a screen so you can talk to it. It is so much fun to have under every instruction quotes from defense witnesses establishing that instruction. And then you can sit down, it lets you argue that you don't have to listen to plaintiffs to believe this. You don't have to listen to me. If we just listen to what the defense said, they've told you, you really have to vote against them.
What a great idea.
And it's remarkable. The jury grabs it and they go for it. I'm
Wait. Anybody?
going to get out of here yet.
You're just trying to help Steve out. I let him sweat. He needs to sweat a little.
Pucci, I'm trying, buddy.
Thank you very much. Good job, Thomas. Good morning. It's Pucci, right? See. See. I'm going to see my father's home in Italy in the fall. The next speaker, Steve Pucci, is going to speak to us about spotting third-party cases for injured workers. He is the 2011 president of the Oregon State Trial Lawyers Association, Bar Association. He's a member of ABOTA, the American Board of Trial Advocates. He's been selected as Oregon's top trial lawyers and super lawyers, and has had that selection over and again. He's a state delegate to the Association of Trial Lawyers of America. He's a president of the Oregon Trial Lawyers Association. He's a graduate of the University of Illinois in 1976 and received his degree from Gonzaga in '81. You know, years ago at Ann Arbor, there used to be a seminar called, it was a name for a trial seminar. And it was held there at the law school in a huge auditorium. Must have been 3,000 people in this thing. And they'd invite lawyers, supposedly good lawyers from around the country, both plaintiff and defendant, and they'd do a mock trial where you were given 10 minutes to do direct, cross, and you had 2 lawyers on each side. So you'd do direct, and then I'd come out, I didn't get to hear yours, and I'd do direct. and then they'd be crossed and so on. And it was an extraordinary seminar, really a great seminar at that fine university that you went to. But you went to the right law school. I'm proud of you for that. That was good. Well, thank you very much, Steve.
Mr. Luvera, thank you very much, is talking about Gonzaga School of Law, which back when I went there was kind of a bomb shelter with a roof on it. And thank you to Paul and his wife. They've just done a tremendous job of bringing it into the modern age. It was a great school then. It's much better now. But there is the Luvera Law School building, which when I went in there, I felt very sad that I was as old as I was and didn't have the benefit of the modern facilities that Paul and his wife were so kind to help the school develop. It's a great place, and thank you very much. You know, something that Tom Booth said about the jury instructions is something that can be said about my subject as well. With Gene Hallman, who's down here from Pendleton, Gene and I have been doing these third-party employer liability cases for, I don't know, since the late 90s. And the one thing that I have always felt that I had in the back of my pocket was the power and the strength of the jury instructions regarding Oregon's employer's liability law. I'm talking about cases where injured workers are looking to find a third party that they can sue, because of course you can't sue your employer, at least not for tort very often. But the law in Oregon is wonderful, perhaps the best plaintiff's law that we have in the state on the tort side. And when we go to argue at the end of the case, oftentimes it's a jury instruction that says if you find that the defendants violated a safety regulation, such as whatever, they are guilty, or they have violated the Oregon employer's liability law. And so, just as a segue, Tom, I think that applies in many cases, but when you go into a case and you know you have the law on the side, you're in a pretty good place to start. In your materials, there's a couple of memos, an article Gene and I wrote on the Oregon employer's liability law, and a short memo on Washington claims against general contractors. You guys in Washington have as good or better law, I think, as we do in Oregon on that. And the thing that I wanted to point out to, especially the claimants' lawyers, who we know your work is a labor of love, because you need a bunch of cases, you need to work hard, you need to, keep the pedal to the metal, and it is very difficult to take a breath and look around and see what kind of case you have and what else can you do for your client besides get them the benefits that they're needed. And so hopefully just a couple of tips you can keep in your pocket. One thing that sounds pretty obvious, but when you've got an injured worker who has a big lien or who cannot return to his or her regular employment, that's a red flag, because nobody's really going to do a third-party case with a comp lien if it's a smaller case. It really doesn't pay off too much. But when you really have big damages, either economic or medical, or you can't return to work, just think about that. Look around. What is it that caused your claimant, the plaintiff in the third-party case, to be in such a pickle? And my second tip would be, don't think of it like an auto case. Don't think about what really is or is not reasonable, or what is due care or not, because the key to these cases are the safety regulations. And the safety regulations, whether it's federal OSHA, Oregon OSHA, WSAJ, they're wonderful things, because it sounds simple, but actually the law is that the workplace is supposed to be safe for all workers. Funny thing. And when you look at cases just like an auto case or straight up negligence case, you start worrying about things. And we've had cases where a plaintiff will look at a pile of debris that's in his way and try to step over it and fall down, break his hip, and never work again. Well, if that was just a straight premises case, you'd be in some serious trouble. But when you get to the regulations and you look at the construction division OSHA rules, well, there's housekeeping rules, there are rules of inspection that apply to the general contractor, the captain of the ship in these construction cases, and they are responsible for making sure that debris gets swept away from working surfaces. They're in charge of making sure that safety inspections are done on a regular basis. In fact, specifically on a daily basis, site-specific safety tours or cruises or inspections of what work is being done that day, who's going to be doing what, and is it a safe place for them to work. Now, so really, if you have an injured worker with big injuries or damages, just think about it for a few minutes and check in with somebody, either us or somebody else who's handled these cases. There's a lot of us out there. On the Oregon side, I'm not as familiar with the Washington experts on this subject, but the duties of general contractors in both states are very severe, really, and at least in Oregon, on many cases, the general contractor can't even give away the safety duties. So, thank you. So you know, you need to take a breath, think about what's going on here, and try not to think too badly about what your client maybe did or didn't do. We've had people falling down elevator shafts that were uncovered that they knew about and have gotten very good recoveries because that is not their job. This one particular plaintiff was putting up a wall, and he needed to get around this corner with his nail gun, and as the nail gun popped away from the extension cord, he stumbled backwards away from where he was working into this hole. People have to do their jobs, and these safety rules are designed to let them do their jobs and not specifically worry about the traps that are set out there by others. So I don't have much time, but look, if you ever get a copy of or go online of the OSHA or the WSAJ regulations, they have these divisions. They have they have general safety rules. They have rules of construction. They have divisions for maritime or agricultural work. And just looking at the headings in these in the table of contents, you will quickly find out that there are some serious regulations that, if not complied with, are violations of general contractor duties. As well, there are you can look to the subcontractors. You can look to anybody besides the plaintiff. But my main point is, don't worry about plaintiff or plaintiff's employer negligence that much when you're taking a fresh look at a case. The only way in Oregon that a plaintiff can lose if the plaintiff or his employer is at fault, besides from getting into the comparative fault issues. In Oregon, we don't have pure comparative like you guys do. But if the sole cause of the injury was the plaintiff or the plaintiff's employer, then that's on the verdict form. If it isn't, the employer's negligence is never going to come into the case. So there are just some twists to construction injury cases that don't happen in regular tort law. Your friend is the regulations and the jury instructions, and as much as defense lawyers hate the fact that they do not get an instruction that, hey, if we used reasonable care, we did all we could, that's too bad for them. This is one area of law where plaintiffs are to be protected with safe workplaces, and when they're not, you probably have a case somewhere. So take a look for that. I think I'm out of time.
Yeah, but hang on, I want to ask you some questions. Thank you.
Okay.
Okay. Steve, my question is, what is it that you would want lawyers to look for in incoming cases that would represent to them a third-party claim? You follow what I'm saying?
Well, you need to know what actually happened and not just what the plaintiff did. I mean, you really need to know why it happened and who else was there. Oftentimes, these booby traps are set up a day or two before by people who you don't even see on the job site. So you really, a good investigator, and actually some of the best are the OSHA investigators who will do the job for you, though they're trying to bust your guy's employer and not the defendant. But if you've got the OSHA file, or if you got an OSHA file, you're in very good shape. But you need to really investigate the facts of the case.
And is the OSHA investigator or the L&I investigator available in Oregon to testify as a witness for you?
They can testify. They certainly do not want to, and it appears they've been well trained to try to get out of it. But really, their findings are not admissible, and they are not.
So the report isn't admissible?
That's correct.
Not admissible?
Not admissible. In federal court, you might get certain reports into evidence, but the OSHA reports, they're looking at a whole different thing. Their burden is just whether, well, there's similar burdens, but they're looking to cite them, and they're not looking to prove liability.
In some of these cases, I'll get you. Some of these cases, your worker is himself or herself at fault to some degree, right?
Correct.
Before I ask you how you handle it, let me, so I don't take the wrong course with you, Steve. I'll give you an example. We had a case involving two men in a bucket. They're doing construction work. The person that I represented had the choice of had the job of watching out for the power line. They knew it was there, they knew it was high voltage, and he was supposed to watch for it. And one day they hit the power line. He ends up a quadriplegic. Okay? Now we have pure comparative negligence.
That's a lovely thing.
So this case settled on the eve of trial for a sufficient amount of money. My plan was to say to the jury, jurors, we have the job here of determining the relative fault of each party involved, the power company and Joe here. To the degree that Joe may have contributed to something, he cannot recover. Okay? So I'm going to save you a lot of work. Joe was supposed to watch for the power line and he didn't. But that's not the end of the case, because we now have to compare the responsibilities, et cetera. My point is, I would have, instead of trying to defend Joe, I would have conceded without giving up the ship in voir dire. And I'm just curious how, and I don't mean that's the standard, I'm just curious how you would have, or how that's normally handled.
Well, each case is a little bit different, but when you do, it's pretty obvious when your plaintiff has some piece of the fault pie, and if you don't admit it, it's going to hurt you. So, I mean, just like anything else, admit your weaknesses and make the case about what the defendant did wrong, and that's really what we try to do.
Good. Somebody had a question. I did, but you asked it. Mental telepathy.
Oh, my question was, and I just recently got one that got a case against a big general contractor where they're doing work on a hospital and some stairs weren't properly constructed.
Yeah, good. Thank you, Blaine.
Injured his hip.
He had a case against a large hospital, general contractor, is that what you said?
Yeah.
Okay.
And my client fell down some stairs and injured his hips. And these were temporary stairs that are no longer there. And we had some informal discussions about some documents about safety meetings that they had talking about the quality of the stairs and the condition of them. And I just got the documents back, and 10,000 documents. Oh, we don't have anything. I'm like, okay, well, that's fine. So I guess we'll see what you have when I get the discovery responses. So we don't have anything, turns into 10,000 pages of documents that I've yet to go through because I just got them last week. But do you typically rely more on your experts to find these safety violations, or do you comb through all the company's documents?
Actually,
dump?
that's a very good question.
Good question.
Because, no, first thing we look for is the safety manual, the contracts between the general and the subs and the employers that your guy's working for. Because you will find that your case, you can win your case on their documents. And There's a big difference between purchasing a safety program and implementing it. And that's where all the injuries happen, because they don't. They buy a safety plan and then they don't follow it. And so when you get to the heart of the matter, look for the safety manual, look for the contracts, and then start flipping through the 10,000 pages, because really, most of the time, it's their own documents that are going to hang them. And I meant to make that point, so thank you.
By the way, my experience has been this. When I've relied upon experts, they've done a good job and found documents. But I have a lawyer in my office, Robert Galatly, who was trained as a defense lawyer before I saved him from the dark side. And he goes through these documents individually. And what always amazes me is he inevitably finds not one, but 2 or 3 things that are really smoking guns that somehow were missed. And so I hate to tell you this, but experience tells me you're going to have to go through 10,000 documents to be absolutely sure.
Yeah,
Anybody else? Yes.
Just a one-on-one comment about Oregon third-party liability. Those of you who don't know, if you're a general contractor has a non-delegable duty. So if you have an employer that doesn't follow a safety regulation, that general contractor is responsible for that.
That person should have inspected or supervised in a way so that no one was permitted to be unsafe.
But it doesn't, yeah, right, it doesn't matter. I mean, if the employer violates the safety regulation, the general contractor is responsible for that. That's the law in the state of Washington.
Good, thank you.
The other thing to look out for is temp workers. That's another real ripe area for third-party liability when you have temporary workers.
Good point.
You could do a day on that.
Yeah, you could. Thank you. I'm sorry. Steve, that was great. I
Thank you.
appreciate it, and I'm glad you made it. Thank you.
Thanks, Paul.
What?
There's one more question.
No, only if I call for him. There is no more question. Thomas, you said something that just dawned on me about using your iPad to video depositions. Did I hear that correctly? Yeah. Tell me quickly about that, please.
We don't do it. We have a small camera, but Kelly presented on Thursday, was earlier presenter, was talking about using his iPad for it. The fact of the matter is, if you're doing employment law in Washington, it doesn't matter whether you hire a videographer or do it yourself, it's all compensable. You're going to recover for it. Or if you're taking depositions in Oregon, it's light years behind Washington and Missouri. It's just a way of saving money. But the iPad 3 has the capability of videotaping.
Great.
You can prop it up, turn it on.
Thank you very much. You know, in New York, a woman named Deborah Chang, who works for a great trial lawyer in California, Brian Panish, gave an entire talk about, this is a guy who's had the $100 million verdicts. He's an extraordinary guy. And she does, in addition to everything else, she does all of the courtroom. And her talk dealt with the use of the iPad in the courtroom. They do their entire trial using iPads. And it was fascinating to me. And I know you had a talk earlier about that same subject, but I was just intrigued by how they use iPads. Brian Honerto, since 1982, has been the coordinator for the Washington State Trial Lawyers Association Amicus Committee and the Foundation Amicus Committee. In 1985, he received the President's Award for his work. He was awarded the Pillar of Justice Award for his longtime service there. He's a member of the American Academy of Appellate Lawyers. He's a former chair of the Washington State Association Civil Rights Committee. He's a co-editor of the Appellate Practice Desk Book and the Revised Desk Book. He received his degree from Gonzaga in 1973, where he's a professor. He teaches appellate law and is involved in national moot court competition. George Aaron is the co-coordinator of the Washington State Association for Justice Foundation Amicus Committee and maintains an active an active appellate practice. Their subject is trial court preservation of error. Now, what's happened is we've got enough time. They had 10 minutes, but because the amicus work is so important, we're going to divide that time. I'm going to hold you to it, but we'll divide that time so you get 10 minutes each. If you go over, God will strike you dead. Brian is so old that he was at the 1986 first seminar of this kind ever held. Isn't that right, Brian? So we've been doing this since 1986, and he frequently speaks here. And so let's start with you, Brian.
Thank you very much, Paul. It's a pleasure to be back here. And with being in the Luvera seminar comes a great responsibility to try to say something useful and meaningful. And George and I thought it was maybe time to revisit a subject that is something we always don't keep in mind as trial lawyers, and that is how to preserve error in the event that either you lose or you're facing an appeal by the other side when you're a winner. And you need to know how to go about doing things right in the event that you have to head to the appellate court as a loser, or how to keep the other side honest about what it can raise in the appellate courts. And we're going to go through quickly a list of 10 things on do's and don'ts that might refresh your memory on a number of things. It's a delicate topic. It's kind of like Herman Kahn wrote a book back in the 60s, in the days of when everyone was worried about thermonuclear war, and it was called Thinking the Unthinkable. And so as trial lawyers, the focus is on trial, and you're not always got your eye on the ball of a rather knotty legal issue that needs to be preserved and you have to go through the paces on. A lot of that can be solved by preparation. But it's a useful endeavor, and sometimes it's the way we end up making good law. The first thing I want to say is to remind you, and I think these remarks should be useful to Oregon lawyers too, although we have no background in the Oregon rules of appellate procedure. But in Washington, the appellate rules are quite generous. And if you look at RAP 1.2, it says that the court will try to get to the case on the merits. Oh, that's good news. However, that will only help forgive errors made at the appellate level. And it will not help you in the trial court. The rules for trial court preservation error are very Old Testament. You must dot your I's and cross your T's. And however sympathetic the appellate court may be, that issue may not be reached otherwise. And you say, why is that? Why are they being so stingy? I mean, if they say we want to get to the merits, why not? The general notion on preservation of error is a matter of conserving judicial resources. You want to give the trial court the opportunity to correct whatever mistake was made. And if you don't give that trial court a fair opportunity, the appellate court is not going to be sympathetic towards you. The other thing that's at work is that doctrine of judicial restraint we talked about in law school. An appellate court only decides what it has to decide. And usually the appellate court will first ask, is this issue properly before us? And if you don't get past square one, you're toast, no matter how juicy your issue may be. And you're a victim of judicial restraint, what the wags call issue avoidance. But it is legitimate. So, watch out for the trial court rules of error. Take RAP 2.5 with a grain of salt. But it does tell you there are certain exceptions to preserving error below, but they're really quite narrow. And the general rule is, if you didn't preserve below, we don't want to hear from you above. The second thing is, and I've been evangelizing about preservation of error for a long time, and things haven't changed much, except not many people look through the advance sheets anymore. If you pick up an advance sheet in Washington and you start on the first page, the first heading you reach is probably appeal and error. And on any given day, there is a list of cases dealing with appeal and error, and it usually has to do with something somebody didn't do right. Now, they might have chosen not to do that. There are those occasions when you make a tactical choice in the heat of trial not to preserve something, but I'm afraid that many of those are because we're just not attuned enough to what is required of us. So on any given issue, and in as many of these issues as possible, you must try to anticipate them as a trial lawyer before trial starts. You only have to ask 3 questions. And these are on page 360 of your materials. Our materials begin on 359. One is, have I sufficiently explained my client's position? Number 2, have I invoked the proper procedure? Does it take a motion to strike? Will a mere objection do? Do I have to make that motion for mistrial? Do I have to put on the evidence in colloquy? Or can I make an offer of proof? All those various mechanisms for preserving the moment. So you've stated your client's position. You've invoked the proper procedure. You have to make sure then you have a record. Sometimes the most obvious thing is overlooked. If you're up there, if the court's called you up, colloquy sidebar, and the court reporter isn't there, what's said there may be worthless. You may have to run the risk of irritating the court and saying, Your Honor, we need to get this on the record. Is it a good time for a recess, or can we call the court reporter up, or how would you like to handle it? Record problems are difficult, and they often, we have resistance to them. Why? Because they break the rhythm of our trial. And you're thinking about tomorrow instead of today. It's counterintuitive, but you have to do it if the issue is big enough. And of course, that's a whole other subject, picking your battles. You can't fight about everything, but you've got to determine what is this, and is it prejudicial error that I'm facing here? If so, then you want to keep everybody honest and give that trial court the opportunity to right the ship. We identify a couple specific areas of problems. And one is motions in limine. And young lawyers especially, you can get really intimidated in your first trial, and you're called into the judge's chambers in maybe some cow county, and the judge says to your opposing counsel, well, hi, Charlie, how's the kids and the grandkids and all that? And there you are, and you're introduced to the judge, and then you go through your list of motions in limine, and the judge peels off decisions on them, and he says, well, let's go pick a jury. And nothing is on the record. And you have to say, well, Your Honor, we need to preserve these rulings. And if you're smart, you might have an order that can be quickly dispensed with, or you're going to have to insist that your client's rights be protected by getting this down and memorialized in some way. So motions in limine, very tricky, especially for those who are new on the block. Evidentiary, the one other thing I want to talk about is summary judgment, and I jumped a little bit. Well, two things quickly. Novel theories. You may be trying this as a straight-up traditional negligence case, but there might be a new theory out there, perhaps an implied cause of action under a statute, perhaps a new strict liability theory that the trial court probably doesn't have the will to recognize, but you must nevertheless preserve it at that stage of proceedings if you want to talk about it later on. If you happen to lose on the negligence claim and you want to fight another day on a new frontier, you have got to risk irritating the trial court by putting together your theory in some kind of a kit that will be your preservation of error for later on. It doesn't have to be grandiose, but it has to be workmanlike. And so watch out, novel theories. Don't think you can have a bright idea at the appellate court for the first time. They don't like it. They just don't like it, and it looks desperate. Now, summary judgment records, another area for some peril. Why? Because we tend to write great summary judgment briefs, and we have this section laying out all the facts, but we haven't matched our testimonial documents to those facts we think so important to put in the brief to make sure that it all lines up, that we have a record for every single key fact that we're arguing for our side on summary judgment. So be careful about that. It can be stipulations, it can be declarations or affidavits, it can be extracts from depositions, but you still have the same problems of making a record. And unfortunately, we too often see, George and I spend a lot of time reading briefs, and although we're here talking to you today as civilians, so often something is missing from the record. And so you've got to try to anticipate that and see a little bit around corners. With that, I'm going to turn it over to George.
Thank you, Brian.
So to follow on with what Brian said, I thought I'd share with you California Court of Appeals case that I came across earlier this year. It says, when practicing appellate law, there are 3 immutable laws. First, take great care to prepare a complete record. Second, if it is not in the record, it did not happen. And third, when in doubt, refer to rules 1 and 2. When you have trouble memorializing a record, if you can't present an order in a timely way or even after the fact that would memorialize what a trial court did, I thought I should point out at least that in the Washington appellate system, you have the opportunity to prepare a narrative report of proceeding, something that is only rarely done, but in Title IX of the Rules of Appellate Procedure, the method is spelled out for you to be able to do that in order to document things for appeal. Now, the risk you take with preparing a narrative report of proceedings is that if there's a disagreement, that gets submitted to the trial court judge, usually somewhat after the fact, and you're a little bit at the trial court judge's mercy if there's a dispute as to what actually did occur. But moving on from the record, I'd like to talk a little bit. Brian mentioned that in order to preserve an error, you have to invoke the proper procedures. And there's a couple, in addition to your summary judgment record, that I want to highlight for today's purposes. First one, and one that's let me say, back up and say, with respect to all of these procedures I'm going to talk about, they're kind of exceptions to the general rule that, you have to make your argument. You've got to have an adequate record, you've got to make your argument. You don't always have to cite the same cases, even though if it's a new theory, you probably should bring that up. But there's a few kinds of error preservation requirements that actually require you to be correct, not only about what you want the court to do, but the reasons that you offer in support of your request for the court to do something have to be correct. And one of those areas that it shows up is in jury instructions. And the text of CR 51 puts the responsibility on the parties to propose the law that the judge gives to the jury, also puts the onus on the parties to make sure that any errors or problems with those jury instructions are brought to the court's attention. And in doing that, you don't just identify a particular instruction that is problematic or specific language within an instruction that is problematic, but you have to take 2 additional steps. One is you have to identify the grounds. Probably this means the authority or the basis for objecting to that particular instruction or to the language in that instructions. And you also, in many cases, have to, except in cases where no instruction should be given, you have to propose your own counterstatement of the law that correctly states the law and accurately reflects the authorities. Brian alluded briefly to motions in limine, and it's hard to know how many evidentiary objections are going to turn into an appeal because of the generous standard of review, at least outside of the summary judgment context. It's an abuse of discretion in Washington. And evidentiary objections are so often subject to harmless error analysis. ER 103 says an evidentiary objection really has to affect a substantive right of the party, and that sometimes can be difficult to demonstrate. But like with jury instructions, evidentiary objections, you have to identify the proper basis for the evidentiary objection, and this would, of course, apply to motions in limine as well. With motions in limine, where the problem happens is the judge oftentimes is going to say, I need to wait and see how the evidence is going to come in, or wait until trial until we get a little bit further along. Your motion in limine does not preserve your evidentiary objection if the judge defers ruling or if the judge is arguably unclear in his or her ruling about whether that evidence comes in or stays out. And if you want to preserve your objection, you're probably obligated to renew the objection at the time the evidence is offered. With these evidentiary objections, when evidence is excluded, you also need to be aware of the need to provide an offer of proof. This gets back to not only preserving the error. ER 103 in the state of Washington does require an offer of proof if the import of the evidence isn't readily apparent from the context in which it's offered. But you also, apart from making the offer of proof, you have to be careful not to introduce similar evidence that would potentially waive the objection that you make. Moving on from motions in limine and evidentiary objections, I want to talk about reconsideration. One of the things that I've often seen in my practice as an appellate lawyer if there is a gap in the record that is assembled in response to a summary judgment motion, then oftentimes I hear trial counsel say that, well, I can just file a motion for reconsideration and put all the stuff that I probably didn't realize was significant or didn't put in the first time around. And you need to be aware that, and sometimes defense counsel will allow you to get away with that on a motion for reconsideration, and there won't be an objection that you haven't satisfied the grounds for reconsideration or that the evidence isn't admissible in connection with reconsidering that summary judgment motion. However, if defense counsel holds you to it, there are specific grounds specified in CR 59A when a motion for reconsideration is authorized, ranging from misconduct of a party to irregularity of the proceedings to the catch-all section relating to substantial justice. The point being that you have to make a showing, or in order to minimize the risk to yourself, you have to make a showing that the requirements of this rule have been satisfied, and then the judge still isn't obligated to consider it because he or she has discretion and is only subject to reversal for an abuse of discretion. And so I point that out as much as anything by way of saying that a motion for reconsideration isn't something that you should plan on relying on to bolster a summary judgment or other motion record. Brian mentioned on appeal, and since we've got a little more time than we plan, I will say the appellate rules for preservation of error are much more generous than they are in the trial court. But I'll tell you, my rule of thumb is you've got to assign the error. That's a basic. A court can refuse. It's not bound to observe its own preservation of error rules, but you are bound to observe its preservation of error rules. And the court can refuse to consider an issue to which error is not assigned. It can refuse to consider an issue for which argument and authority is not supplied. And it can refuse to consider issues that aren't raised for the first time until a reply brief. Aside from those fairly flexible rules in the appellate court, you're pretty safe, as Brian said. And the final thing is, if you're uncertain about preservation of error, I have heard stories where lawyers will go search the amicus brief index on the WSAJ website, search for a topic that has a relationship to whatever motion is pending in the trial court, and then just staple that brief to whatever they file. I'm not sure that I would recommend that, but I do want to point out that there is, even though we're here in our individual capacity, there is some work that has been done, especially with respect to novel theories, constitutional issues, that you aren't probably going to get a trial court to entertain, either because they don't have the institutional authority to make policy, that there might be more conservative or safer ways for the judge to try the case. But many of the issues that pose problems for us as plaintiffs' lawyers, from collateral source rule to statutes of limitation to just about any manner of topic, implicate constitutional rights such as the right to access to justice, the right to equal protection, and there is a fair amount of briefing on these issues and how they relate to some of the standard issues that are going to come up in a trial practice that's available to give you ideas for those novel theories that you're going to want to make sure are in your record before you take the case up on appeal. So I commend that as a resource to you to look at. So with that.
Thank you, George.
Thanks.
Brian, you have a mic, right?
Yes.
Yeah, okay.
Right here.
George, I want to ask you this. My practice is to have motion in limine in writing, the motion. Then it has a box for granted, denied, and then blank lines for the judge to fill in and then sign it at the end. So I come there to avoid the problem of no court reporter if that is the situation. Now, what I heard you say that troubled me a little bit was, assume that I've got an order excluding something. Are you saying that I now have to object when that comes up at trial again? I mean, I would have thought that the lawyer would commit some sort of an ethical violation by violating the pretrial order.
If you have an order, I think that's good to preserve the error. What I've experienced is the judge will defer a ruling, even with the motion, which we've probably copied from you. If you have the checkbox, he'll say, I'm going to have to wait and see. Yeah.
So you need to be on the edge of your chair at that point. So what you're saying, when this issue comes up or is about to come up, you need to be ready to deal with it.
If it's deferred, just filing the motion isn't enough.
All right, good. Yes, sir.
I had a question. I had a situation. I had a medical malpractice trial.
Thanks, Blaine.
I had a medical malpractice trial where the motions in limine were specially set, and we're in one of those courtrooms in King County where supposedly there's not a court reporter, but there's this fantastic audio system that's supposed to be picking up everything, so when you're done with your trial and you order the transcript, it's supposed to be there. But I called to order the transcript after the trial was over, and it wasn't there. We had made our checklist with all the motions in limine, and we're writing down the one that the judge has granted and the ones that are denied. And we go to work with the defense counsel, and we can't come to agreement on a stipulated the order. And we want to take it up before trial, but the judge is like, these jurors have been waiting. You need to get moving. So we don't have a signed order. We know what the judge rules. She knows how she ruled. Things come up during trial, and we did make an objection to preserve them, with the idea that, you have the sidebar and you're saying, Your Honor, you excluded this, and yeah. So, but at the end of the trial, you would hope that you're able to pull this back. What my question is, in our case, a little more complicated because we did not get the signed order, but we did have the preservation on the record during the trial. But assuming we had gotten the signed order, what's more important, the transcript of what the judge is saying when she's making these decisions? Is she waffling or was it very definitive? Or the order that's signed off on the motions in limine?
Let me give Brian a chance. Brian, you get that.
Well,
Have you got the mic?
If the order is sufficiently specific, that ought to be enough. If, on review, if that order is challenged by the other side in the briefing, then you might want to then supplement the record, move to supplement the record and bring in the transcript to the extent they're now trying to poke holes in the order. If you're really cautious, you're probably going to order up the transcript from the beginning so to take that issue away from them. I think it's going to depend on how specific the order is and whether it covers all bases on whatever the issue is at stake.
George, did you have, I'm sorry. We go ahead.
Just in
if it's short.
Is there ever a problem with making the objection for the second time during the trial, even if you've got a motion limiting on it?
Not other than other reasons, not for preservation of error purposes. It's belt and suspenders are fine, but for drawing attention to it or other reasons you may not want to.
The only problem I would say, and I've seen this in a case before, is if you had a different judge who made the first ruling, watch out, because that's an interlocutory ruling, and your trial judge could come along and change it. So in that instance, if you have a change of judges, beware.
I have another issue. My practice is, because judges keep deferring offers of proof, they don't want to stop for them. My practice is to type out in writing offers of proof and either mark them as an exhibit or file them. What thoughts do you have about, I don't know if you're aware of what I'm saying. Oftentimes judges keep putting it off, and you forget. You never get that offer of proof made.
I think that's a great idea, probably because you also get to give it a little bit more forethought than just winging it.
Yeah, okay.
Paul, do you then have it marked?
Yes.
And have it admitted as a side exhibit?
I mark it as an exhibit and let the judge worry about what to do with it. I just want to make it part of the record. And I raise a big fuss, and if they let me make an offer of proof, it's pretty elaborate. I'll go as long as they'll let me. Yes?
That's very efficient, by the way.
That was going to be sort of my line of questioning. What's an effective offer of proof, in your opinion? What needs to be in that filing information there?
Well, I guess this is a little bit off of the cuff because it's probably going to depend on what the evidence is and what the objection is. But I would want enough information in there both to show why it's admissible, it's relevant and whatever else, and how if you can get something in there, how it responds to whatever objection, say it's excluded on hearsay grounds and you've got some reason to, some way of getting that, or getting around the hearsay rule, I would want those two things as part of it, and that's probably going to include the substance as well.
Just be a second. If I can ask this question, I'll be right with you. Ask this question. Exceptions to instructions are important. What I found is judges oftentimes don't want to listen to those. So I have a form I use with language that I make sure I use every time. And I fill in I have the numbers. I have a sheet that says what I proposed in exchange. And I only say that because you're rushed, and the judges are often rushing you. And it seems to me, I need some kind of a format to make sure that this is the one area that I am concerned about preserving error.
Well,
on the exceptions are
and this is the biggest area for a trial lawyer. Why? Your focus is on final argument. You're fatigued. You're at your worst at this point in terms of being technical. And so what Paul's saying is just solid gold. All of this work, there's going to be a few things that come up in trial that you're going to have to scramble before. But most of these preservation of error issues surrounding jury instructions should be taken care of long before the opening gavel. And if you can have it chapter and verse typed out, better yet, and submitted to the record. I've actually remember Bill Williams, who went on to be the Chief Justice of the Washington Supreme Court in a case I tried on Med Mal. He said, oh, let's do the exceptions afterwards.
Yeah.
I want the jury to get this submitted. Well, I was 25 years old, and I wasn't going to say no, and thankfully it didn't hurt me. But watch out, young lawyers, for a judge that says, oh, we'll do that later.
Do that later. Yes, sir. Go ahead, I can hear you. Blaine can run.
I assume that I've done a proper motion when the judge has overruled me, the defense has put in the evidence that I didn't want. Do I have to do anything to preserve error in addition to that before I put on the...
All right, the question is, he's made his motion in limine, it's been granted or denied, the evidence comes in, he objected at the time it comes in. Does he still have to do something else to preserve the error? Is that right? Yes.
I don't think so. You just need to be careful not to introduce similar evidence or do other things that would waive the objection after the fact.
Probably not, but my middle name is Overkill, and I would make a motion to strike before I finally sat down. Once the evidence came in over your objection, I would probably make a motion to strike one last time on the record.
And the one thing that I would add is getting to the harmless error problem with evidentiary objections. Oftentimes you're going to need to ask for a curative instruction or a motion to strike or something after the fact.
We need to wind this up. One more question. Yes, sir. Just because you're an important lawyer. And my friend. Yes.
On this motion in limine deferred situation, do I have to object when my opponent gets up and starts talking about this bad stuff in opening statement? And can I say anything about it in my opening statement to try to inoculate them without waiving my later to be made objection when the evidence would come in?
I don't know the answer to that question, so I'm going to defer. I think, opening statements aren't evidence, so I don't think you have to object. And I think you can anticipate if I would probably raise that with the judge, say, okay, now if you're going to defer, I'm going to have to preempt this in my opening. But I would defer to somebody who's got more trial experience than me.
And I'll just say this: if you probably were doomed if you didn't get a clear ruling from the trial court in the first instance, and then if the other side tries to take advantage of that, I do think you have to object at that point in time. Okay. And that's why it's so important to try to seal these things off beforehand.
We got to quit. Thank you, Brian and George. Absolutely great. Blaine, I know you have something to say. Before Blaine takes over, I want to say how thankful I am to each of these speakers. I mean, I'm pretty cruel to them. Before they get up to talk, I make sure that they're stressed beyond belief and so on over the time. And so, everybody today did such a magnificent job. It's really a lousy job if you've never done this before. You only have 10 minutes, and you got this old bastard who's on your back the whole time with a timer, for goodness sake. So
it's like playing in Yankee Stadium.
So, it's true, bro. So I thank you to each and all, and thank each of you for being here. I just am so glad to see people who are still learning. I don't care how old you are. If you just continue to do the same thing you've always done, you're going to stagnate. And, bless all of you for coming here and being learners. I'm really proud of all of you. Thank you, Blaine, for all your help, and I know you want to say something.
What's your love for Paul Luvera? Have a good afternoon.